Hello, everyone. We're going to talk about intestate succession today. So, this is the legal process that determines how a person's property and assets are distributed when they die without a will or if they have an invalid will, which is a topic for another day. So, think of it this way. When you're writing a will, you're creating a set of instructions for what should happen to your belongings after you're gone. If you don't have a will, the state provides a default set of instructions for you. And these instructions are the laws of intestate succession. Here's a breakdown. Intestate means dying without a will. When this happens, your estate is subject to the rules of your state. So the state makes a plan for you, and each state has its own specific laws, but they generally follow a hierarchy based on family relationships. So the most common order of inheritance is 1, your spouse and children. They are usually first in line to inherit. 2, your parents. So if you have no spouse or children, your parents will likely inherit your estate. 3, your siblings. So if you have no spouse, children, or parents, your siblings will typically inherit. 4, more distant relatives. So if none of the above exists, the state will look for other relatives, such as grandparents, aunts, uncles, or cousins. And trust me, when money is involved, cousins twice removed show up out of the woodworks. And 5th, which surprises the most people, is the state. So, in the very rare case that no living relatives can be found, your property will go to the state. But even then, a lot of people in America have estranged relationships with their family and would not want their money to go to certain family members. And this is why one of many reasons why creating an estate plan is very important. So, not all property is included. So, intestate succession only applies to assets that you own in your name alone and that you don't have a designated beneficiary. This means it doesn't apply to things such as 1, accounts at financial institutions with a named beneficiary, because you've created a contract with this financial institution listing who that beneficiary is. 2, a property held in a living trust, reasons to have an estate plan. And 3, assets that you own jointly with another person. It usually passes automatically to the surviving co owner, but it also depends on how title is held. In short, if you die without a will, you lose control over who inherits your property, and the state's laws will decide for you, which can be a very complicated and stressful process for your loved ones, which is why estate planning is recommended. I know I want to be holding the remote control. Now, let me spill some tea and give you some real life chisme. I'm the administrator for an estate where everything is going to a local community college per the decedent's will. Now, the decedent was never married, had no children, and his parents had already passed away at the time of his death. But his siblings tried to destroy the will because if there was no valid will, it would all go to them through the laws of intestate succession. Long story short, justice found a way and the will got into the right hands. We will talk about how to protect your estate planning documents in another post. But so far, thanks for joining along.